Call next case on the docket, case number 104474, State of Kansas, Appellee v. Israel G. Mireles, appellant. Before we begin oral arguments, there is a good chance that counsel will be referring to some of the facts of this case, and I wanted to let our guests in the audience know that there may be some disturbing facts that come out, so I just wanted to warn you. Very good. Please proceed.
May it please the Court. I'm Deborah Wilson of the Capital Appeals and Conflicts Office. I'm representing the defendant appellant, Israel Mireles. Justice Nuss, I'd like to request 3 minutes rebuttal time today.
3 minutes is granted.
Thank you. Mr. Mireles was convicted of capital murder in the death of Emily S. He was also convicted of rape. He's currently serving life without parole, plus an additional sentence of 203 months. The primary issues in this case are the court's failure to instruct on the lesser included offense of felony murder and the prosecutor's comment in closing arguments expressing his personal opinion that the facts in this case did not support the jury's consideration of lesser included offenses. We have one other issue in the brief regarding gruesome photographs. I'd like, with the court's permission, to submit that on the brief. Since the briefs have been filed in this...
Let me ask you briefly about the photographs. The exhibit number 131, I understand there may have been a preservation problem if you didn't.
There may have been. I didn't find an objection to the record to exhibit 131, and how it got to the jury room is kind of a mystery to me. The parties handled the issue of the photographs at a pretrial hearing, and at that pretrial hearing, defense counsel entered her objections to certain photographs. Exhibit 131 wasn't mentioned at that pretrial hearing. That's why I think I may have a preservation problem here. However, the odd thing that happened in this case was that 131 wasn't mentioned in the pathologist's testimony at all. So I'm wondering if anyone knew that was actually in the packet of photographs that went back to the jury. And of course, 131 was an extremely troubling photograph. It's one of those kind of things that you can't unsee. And the thing that was troubling about this photograph was the photograph was of the victim's nude body, and it appeared that she had suffered an external genital mutilation in that photograph. And when I saw it, I was really taken aback, and I was trying to figure out what had happened there, because of course the pathologist's testimony was that the injuries to the victim's vagina were all on the inside, not on the outside. And so I thought this jury may have thought that in addition to those internal injuries, that the victim had been mutilated in this way. And so that's why I brought it to the court's attention. It's an extremely disturbing image with no context. That's the big problem. I assume what we see in the photograph is the result of decomposition or insect activity, but there's no explanation for it, and that's why it's so troubling and so prejudicial.
But is there an order from the court admitting it?
Yes, the court admitted the photographs as a group, and so they went back to the jury room with.
But it wasn't identified by number.
No.
The admission order.
No, it wasn't discussed with particularity during the testimony, and you're right, Justice Johnson, I may have a preservation issue, but it's...
Was that order pre-trial, or was that order during the trial? There was a motion to admit during the trial, or had that been taken care of before?
It had been taken care of beforehand, and then there was an admission of just the group of photographs, as I recall. But I recognize I do have a problem with preservation in this case. Turning to the felony murder issue, since the briefs have been filed in this case, there have been new developments on that issue. Those are, of course, this court's decision in State v. Cheever and State v. Williams. In Cheever, this court held that felony murder is, in fact, a lesser included offense of capital murder. And in Williams, this court clarified the analysis for determining whether the failure to instruct on a lesser included offense is clearly erroneous. And that's the standard we have to use in this case because Mr. Mireles didn't request an instruction on felony murder at trial. So I'd like to jump to the Williams analysis. Under Williams, The first question is whether the instruction was legally and factually appropriate. If this court finds that it was legally and factually appropriate, then the next question is whether this court is firmly convinced that the verdict would have been different had the jury been instructed on that issue. Turning to the first question, we believe that this court's decision in Cheever renders the instruction legally appropriate. The question of whether the instruction was factually appropriate requires us to view the evidence in the light most favorable to the defendant to determine if it would support a verdict of felony murder, or whether the evidence adduced at trial excludes the possibility of guilt on a felony murder theory. And it is true, some of you may be thinking, well, Mr. Mireles' primary defense at trial was that Emily S., that someone else killed Emily S. while he was away from the motel room. However, Mr. Mireles also defended on alternative grounds, those grounds being that her death was not intentional or premeditated. And along with that defense, he requested and he received an instruction on voluntary intoxication. So in the light most favorable to the defendant, we have a wealth of evidence that leads to the conclusion that Mr. Mireles certainly did not, when he went out that evening, have the intent of killing anyone. As the court will remember from the facts, Mr. Mireles basically spent the entire evening calling attention to himself. And he had to have been aware that many of Emily S.'s friends and associates, and even her own brother, knew that they were leaving the retreat bar together that night and returning to Mr. Mireles' motel room. Additionally, Mr. Mireles was described by witnesses, like Emily S., by witnesses as being extremely intoxicated as the evening wore on. And the jury could have formed that his intoxication impaired his ability to either premeditate this crime or to form the intent to kill.
But they didn't.
They did not. They did not.
I mean, you got the instruction and they didn't.
Well, he got an instruction on premeditated murder as a lesser and an instruction on second-degree murder as a lesser. And I think maybe, Justice Rosen, what you're sort of suggesting to me is we maybe have kind of a skip rule situation in this case, because that's the thing that I thought about when I was considering what instructions were given and what the verdict was.
Not only necessarily a skip rule, but the overwhelming evidence of premeditation that occurred in that room.
You know,
during the act. Explain, in your brief, you seem to suggest that it could have happened this way, could have happened that way, but the jury discounted that. That's probably because of the overwhelming nature of the evidence in this case.
And I was thinking
of premeditation.
And I was thinking you might also ask, how could this not be an intentional killing? And I think there is a possibility that the injuries that were fatal could have been inflicted in an attempt to subdue Emily S., rather than with the intent to kill or with premeditation. And when we talk about whether the evidence is overwhelming, what I think the state has in this case is strong evidence of identity. I think the state has a very, very strong case for identity. But I think the evidence on state of mind, which is important when you're talking about a premeditated or an intentional crime. Well, it's absolutely essential, more than important. The evidence of state of mind, I believe, is in fact weaker, given the defendant's intoxication and its chance of impairing his ability to form the intent. And also,
How does that play into felony murder? Because felony murder would require that he have the specific intent to commit rape.
I know, and that's what makes this, I think, such an interesting issue when you think about the crime that was charged in this case, the crime of capital murder under the subsection of premeditated intentional murder with an associated sexual offense. What's so interesting about this is that crime encompasses two separate crimes, one a specific intent crime and the other a general intent crime. And I think that's why it fits these facts neatly, because the associated sexual offense...
Well, I don't know if you understand my question.
Okay.
You're saying that felony murder would be appropriate because of the voluntary intoxication may make it questionable whether there was the specific intent for premeditation.
Or specific intent to kill.
Or specific intent to kill.
Correct.
But to find felony murder, you would have to have the specific intent to commit the rape, wouldn't you?
No. One of my biggest losses in this court, and this wasn't cited to the court because I didn't know this question would come up, was State versus Plunkett. And in State versus Plunkett, of course, what happened in that case was defense counsel argued to the jury, well, my client didn't intend to have non-consensual sexual intercourse with the victim. The prosecutor objected. The trial judge sustained the objection, saying you don't need a specific intent. And this court, and I brought that up on appeal, and this court sustained the trial court, saying that no, rape is not a specific intent crime. You don't have to have, for rape or for aggravated criminal sodomy, you don't have to have the specific intent to have forcible or non-consensual sexual contact with the victim. You just have to have general criminal intent. That's why I think felony murder, especially when you're dealing with a crime that actually combines two different intents, specific intent for the homicide, for the premeditated intentional killing, general intent for the rape or the aggravated criminal sodomy, why that fits so well with this crime. I think, I really think that it is factually appropriate in this case if you look at the evidence in the light most favorable to the defendant. My real hurdle, I believe in this case, the high hurdle for me, is convincing the court to find that the verdict would have been different if the instruction on felony murder would have been requested or given. But to assist you with that determination,
Does the skip rule stop it there?
No, I don't. I guess I misunderstood Justice Rosen because I was thinking he was maybe going down the skip rule path, which is something, the skip rule is something I have a hard time remembering, so I actually wrote it down in case I was asked that question. Under the skip rule, where the district court has instructed the jury on a lesser included offense, but the jury convicts of a greater offense, any error resulting from the failure to give an instruction on another still lesser included offense is cured. That's State versus Plummer. In this case, the court instructed on first degree premeditated murder and second degree intentional. Felony murder isn't a lesser of either two of those. So that's why I think we don't have to discuss the skip rule in this case. I see I'm out of time.
So since I took your time on that, I'll ask.
Oh, okay. Okay.
Why would we feel that a different verdict might have been reached?
Right. I would just highlight again that if Mr. Mireles was sober enough to form the intent to kill, he was certainly sober enough to realize that if harm came to Emily S. in his motel room after basically everyone she knew saw them leaving together, that he would be the first suspect in this case. So I would suggest to this court that points away from an intent to kill or premeditation as well, rather than towards premeditation. Because, and realizing that, of course, premeditation doesn't have to occur 5 hours before the killing, but in this case, it appears that he would have had to have known that he would be immediately sought by the police if she were harmed in his motel room, and that points away from premeditation or an intentional crime, intent to kill in this case.
Counsel, before you sit down, I'd like to go back to a comment that you made just about a minute ago, and you said that felony murder is not a lesser included crime of, and then you listed, I think, two offenses.
Of the two offenses that we're instructed on as lessers. Premeditated murder, felony murder is not a lesser included offense of first degree premeditated murder. They're the same, they're all first degree murder. And of course, felony murder isn't a lesser included offense of second degree intentional, which is the other lesser included offense that the trial court instructed on.
My notes reflect he was convicted of capital murder.
Correct. Correct.
And I thought we said in Cheever that felony murder is a lesser included crime of capital murder.
Yes, yes.
Okay.
But I'm just, under the skip rule, you look at what other lessers were instructed on.
All right,
Right.
I got you. Thank you. Any further questions of counsel? Thank you.
Thank you.
May it please the court, Chris Ailslager, appearing on behalf of the state. And as opposing counsel pointed out, since the filing of these briefs, the Cheever decision came down, which, with respect to the felony murder argument, really takes the wind out of the sails on the first half of the argument as set forth in our brief. But nevertheless, just as I did in State v. Gleason, I still feel obligated to make the argument that Cheever was wrongly decided on that point and try to persuade you to that, understanding that I am charging uphill. If you'll just indulge me for a brief moment to remake that argument again. The lesser included offense that was required to be instructed here was first-degree murder, and that was instructed on. First-degree premeditated murder was instructed. Now, this court has said in other cases that felony murder is not a separate and distinct crime from first-degree murder. It's the same crime. It just provides an alternative method of establishing the elements of premeditation and intent. So, therefore, there is no separate lesser included offense of felony murder. The crime is first-degree murder. That crime was instructed on. And it really doesn't prejudice the defendant to not instruct on felony murder, because felony murder essentially eases the burden on the state by making it easier to prove the premeditation and intent.
But it's a lesser sentence than first-degree premeditated, even though we say that there are two alternative ways of committing first-degree. We impose a different sentence, or the legislature's imposed a different sentence.
Yes, but this court has said in other cases, though, that when you look at whether something is a lesser included offense, you look at the elements and you don't look at the sentence imposed does not make it a lesser included offense.
Well,
I don't have those cases.
We have a statute. It doesn't matter about the cases. We have statutes that define lesser included offense, and one of the ways is a lesser degree of the same crime. And that's how we get to felony murder being a lesser included, is not through the elements, obviously, but through a lesser degree.
Right, but the court has said that the degree is not defined by the lesser degree is not defined by the sentence. I think it's kind of, in the second degree murder context, this has come up, and it said the sentence is not the defining factor. And so, going back to this court's earlier rulings that felony murder and first-degree premeditated murder are the same crime, then the fact that the jury here was instructed on first-degree premeditated murder accomplishes the requirements of the statute to instruct on lesser-included offenses.
Well, go ahead.
Go ahead.
Well, now, here's my question on how this capital case was charged. It was charged under 213439A4, which is the intentional premeditated killing in the commission or subsequent to a rape, criminal sodomy, or aggravated criminal sodomy. Charged under Section 4, don't you always necessarily have to prove the underlying felony? And isn't it always, at least legally, a lesser included felony murder? I mean, you're proceeding on the commission of an inherently dangerous felony of those three being rape or aggravated sodomy or sodomy.
Well, but you still don't need to. You don't have to give the lesser included offense instruction. If the jury doesn't agree that you've established capital murder, then they go down the line and they can see if you've established premeditated murder and so on. But there's no requirement. I don't see how you get a requirement to instruct on felony murder. Felony murder is the same crime.
But at least find that it's legally sufficient in that that's what you have to show. You have to show that the felony was committed in the commission of the homicide. And that's how you get to the capital murder. I mean, it's included.
I still don't think that gets to a requirement for the felony murder instruction, because the lesser included.
Then you have to have facts to support it too. But right, okay.
I mean, the statute just says you have to instruct on the lesser included, and the lesser included is first degree murder. That was instructed on. Nevertheless, I've made this argument before without stellar results, but as I said, I don't want to waive the argument. I feel like I should at least attempt to persuade you to relook at that Cheever decision. But in this case, he didn't request a felony murder instruction, so we look at it for clear error, which requires the court to to reverse would have to believe that there's a real possibility the jury would have returned a different verdict. And as already noted, the evidence of premeditation in this case was overwhelming. The victim suffered multiple blunt force injuries, multiple lacerations. She had 2 stab wounds through her chest that went completely through her chest cavity. She had 2 telephone cords wrapped around her neck and bore evidence of strangulation and fatal ligature injuries. Other injuries I just won't even get into. So there's no other inference that can be drawn from this evidence other than the defendant fully intended to kill this victim and certainly premeditated it. The evidence of strangulation itself would be enough to establish premeditation. The multiple fatal stab wounds, I think, would be enough to establish premeditation. And you add them together, I think there is just no possibility at all that the jury could have returned a different verdict other than premeditated murder. And now my opposing counsel did not get to the prosecutorial misconduct issue. And normally I would simply submit that on the briefs then, but because this is my only opportunity to speak, I don't get a rebuttal. I would simply submit that this case is the same as this court decided in State v. Corbett, that the use of the term I believe or I submit and so on is not an assertion of personal knowledge or vouching for the strength of the state's case, but simply a figure of speech to advance a position.
Well, the problem I have with that is that in this case we have an objection. Usually we don't have any objection. We just have, maybe a misspeak, but we have a specific objection that the prosecutor is not to state his or her personal belief, and the court overrules it.
And correctly, I think, because the prosecutor was not stating a personal opinion. It's a figure of speech. As I think the Court of Appeals, I think Justice Laban wrote State v. Rivera, really hit it square on the head, saying in common speech, we often say I believe or I think or even the stronger I know without actually trying to pass something off as our own independent knowledge. It's merely the use of a figure of speech or rhetorical technique rather than an expression of the prosecutor's personal knowledge. And that's all. Everyday conversation, we all do this. We all say I believe, I know, and so on, without really asserting that that's really our personal knowledge or without trying to vouch for.
And the only other problem with this, because I'm kind of with you on your argument here, is that he did state, I visited the scene, I don't believe. It's coupled with that maybe makes it a little more troublesome.
But I think it really is just a figure of speech, and it would be almost, I think, impossible to require prosecutors to suddenly to forget all of their years of speaking the English language to try to stilt their language into this, stilted method of presenting things. And I love the quote from in the brief from the Michigan Court of Appeals that pointed out that the question is not whether the jury would conclude that the prosecutor believes the defendant is guilty, because that's a conclusion that they would reach in any event. I mean, everybody knows the prosecutor thinks he's guilty. It's just whether or not the prosecutor was attempting to vouch for the defendant's guilt by using some kind of personal knowledge or the authority of his office. And I think in this case that was not present. He was just simply using a common figure of speech and did not commit any error.
Any further questions of counsel?
I'd like to ask you a little bit about the photographs. Quite frankly, this is certainly pushing the envelope in my estimation. Why is it necessary for the coroner to give an anatomy lesson? We've said as long as it aids the coroner in the coroner's testimony, but it seems to me that the coroners get into a little lecture on the human anatomy that's really not necessary, and I see that here.
Well, it happens in I think virtually every case. I get these transcripts, and when I get to the coroner's portion of it, I've got 20 pages of anatomy lesson, and I wonder myself, is that really necessary? But I'm not a trial attorney. At the trial level, they have to.
Let's have a for instance on this case. We had the one body part where we had the panoramic view, to use the description someone did, and then we had all the little individual cut marks. And I'm just, when we're talking about necessary to prove the manner of death, we've had a description that there's been multiple stab wounds to that particular body part, it seems really overkill that we have both a global view and then a minute microscopic view of each cut, that you get into the purpose to inflame rather than to inform or convince.
Well, I would submit that, first off, the old saying, the picture's worth 1,000 words is true. I mean, pictures depict the injuries in a way that merely somebody on a witness stand telling you about it just doesn't capture. And in the case of the minute injuries from the sexual assault nurse's testimony, I think she needed each of those to explain each individual injury. But because of the way, those each individual little minuscule pictures don't give, they're sort of abstract, and the jury...
Well, my question was, why did she need to explain each one of the individual?
Well, I think to show the nature of the injuries. I mean, we had multiple crimes here, beyond just the murder, and again, I'm not going to get into the graphic details, but she needed to explain those injuries. I mean, and it's always easy in hindsight to look back and say, well, prosecutor, you didn't need to put on this evidence and this evidence and this evidence. I mean, I tease the trial attorneys all the time about the extra evidence they put on, but from their perspective at the time, they've got to prove the case, and they don't want to leave something out that they needed.
It seems like I recall decades ago that the rule of thumb was that if you had some gore that was created by the autopsy or the coroner, that was off limits. But here we have a great deal of the gory, gruesome photographs that are such because of post-mortem activity.
And I think there are two cases in the whole history of Kansas where they found error in the admission of photographs named Boyd and Adam, and one of them said the victim's body was splayed out on the table like a side of beef or something like that. But you didn't have that here. Each of these photos related to an injury or an aspect of the injury, and the coroner testified to, and so forth. So you don't have that same standard. And this court has said that even those invasive photographs may be admissible, although it says subject to a somewhat stricter test. That was State v. Green, but the parameters of that somewhat stricter test have never been nailed down. But that doesn't make them inadmissible. And in this case, again, even though you had some graphic images and you did see the results of the autopsy, they were relevant to establishing the manner of death, the cause of death. They corroborated the testimony of the witnesses. And remember, this was a completely circumstantial evidence case. There were no witnesses to the crime to testify, as in I think the case, at least the Adam case was the other one where they found error in the admission of the photographs. So there were a lot of eyewitnesses that saw what happened. But here we had no eyewitnesses. We had to rely only on the testimony of the pathologists and the circumstantial evidence.
How did the gruesome photographs tie the murder to this defendant? I mean, the eyewitnesses wouldn't have been there for manner and cause of death, which is what we always say that the photographs are admissible for, whether they saw this defendant do it or not.
Well, in the Adam case, they could say, I saw him stab him in the chest. But here we don't have anybody to say, I saw him stab her in the chest. So we needed to have the coroner say, she was killed by stab wounds to the chest and by ligature injuries to her neck. So.
Counsel, and this the capital count was solely on the basis of the associated sexual offense, not heinous, atrocious, cruel?
I believe so. I'm just shooting from memory. I'd have to go back and look at the record.
If it was HAC, I mean, then you'd have another possible argument. That's why I was asking.
And I don't know if that was maybe on the table at some point and taken off, or honestly, I don't know if HAC was included. It's been too long since I reviewed the record in this case.
If you knew, I wanted to know too.
Any more questions of counsel? Thank you, counsel.
Thank you, Your Honor.
Justice Beyer, the death penalty wasn't sought in this case, so I don't think the heinous, atrocious, and cruel
with the aggravators
came up in this case. I hope I won't be out of line by taking my rebuttal time to talk a little bit about this misconduct issue, since it was addressed by the state. I think the two primary problems that I identify with the comments that were made in this case were, first, they weren't just made by the county attorney or an assistant district attorney. They were made by the Attorney General of the state of Kansas. So although all prosecutors have a certain amount of authority in the courtroom, these statements were made by a person with even more authority. And then, of course, as Justice Johnson pointed out, the statements were endorsed basically by the trial court rather than the objection being sustained. And although I must concede there's not a lot of evidence or any evidence of ill will in this case, the prosecutor's improper remark coupled with this judicial endorsement, we believe, impaired the jury's ability to give fair consideration to the lesser included offenses. The ultimate question is whether the remarks denied the defendant a fair trial. And the most pertinent question in when you're deciding whether the remarks denied the defendant a fair trial is the nature of the evidence. Is the evidence so overwhelming that the misconduct would have little effect on the jurors? While the evidence, as I've said before, while the evidence of identity is quite strong in this case, the evidence regarding state of mind is not overwhelming. The evidence of Mr. Mireles' intoxication as well as his behavior that night all point away from a premeditated or an intentional crime. And of course, his high degree of intoxication also renders his intent a valid question for the jury to consider in the jury room. So it's our position that this comment, which could have dissuaded the jury from giving proper consideration to the lesser included offenses, deprived Mr. Mireles of a fair trial. And we're requesting the court reverse his convictions.
Any more questions of counsel? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. That concludes this morning's docket. Court is in recess until 9 o'clock tomorrow morning.